Good afternoon, everyone. I'm Hediana from Asian Women Shelter. On behalf of our webinar team, I'd like to welcome all of you to our workshop today. This webinar is actually a continuation of our Indonesian webinar on the same topic in late June. The goal of this workshop is actually to empower our communities with knowledge and understanding on our basic rights in family law in California and in immigration law so that we demystify the law itself and quell misinformation. I want to thank you, the original initiator of these workshops.
Eliana, may I interrupt just in case? Can we slow down a little bit for interpretation?
Oh, okay.
That would be really helpful for the interpreter.
Okay. Okay. I want to thank you, the original initiator of this workshop, our attorneys, Yeni Tengli and Vicky Hartanto, and no less important, our tech powerhouse, Jessica Loman Dickinson, and our Malaysian sister, Lisa Lim. I'm proud and grateful to share that we are able to expand this work as our friends in the Nepali, Tibetan, Arabic-speaking communities were ready to embrace the idea. Thank you to Mona and Rakia from Arab Women Services at Asian Women Shelter, Swastika and Sangita, AWS language advocates in Nepali Zoom room, Siring and Tiki in Tibetan Zoom room, and Avi and Silvana in Indonesian Zoom room. Thank you to all of you, and very special thanks to Crystal, our youth tech wizard, to represent our hope for the future. Before we start, I want to ask one of AWS founders, Becky Masaki, to open the event for us. Becky is not only our former executive director, but she's also our mentor and friend and supporter until today. Becky, please take it away.
Welcome to each and every one of you. Thank you for joining today's free multilingual question and answer webinar in family law, domestic violence, and immigration for low-income and underserved communities. Especially during these unprecedented, harsh times, how meaningful and centering to learn and grow with intention by and for our immigrant, multilingual, multicultural people, our extended families, and communities. I'm Becky Masaki, and over 30 years ago, I was one of the founders of Asian Women's Shelter to meet the unmet language and cultural needs of domestic violence and human trafficking survivors, their families, and communities in our diverse, multilingual, multicultural Asian Pacific Islander communities. And to build a diverse community of bilingual cultural advocates, I co-created and named the Multilingual Access Model, or MLAM for short, to recruit, train, engage, and value bilingual folks in our communities to become paid on-call language advocates. I'm so grateful and inspired by you, many who are in this joining us, who are multilingual advocates. Thank you for being a part of our wonderful, interconnected MLAM family. I simply planted the seeds, and I'm the old yet good roots to the MLAM program. And like an old grandma, I'm so proud and inspired by all of you as you continue to contribute and grow as MLAM, as community members, as workers across and within our very diverse professions and fields. Another aspect of the old story in founding AWS is that in this month of October, perhaps even on this day in October, yet back in 1988, In our first day of opening AWS, Dean Ito Taylor of Apilo and Ernest Liu, they were the first and only Apilo attorneys, invited Mei Sing Saturn and me. We were the first and only Asian Women's Shelter staff at that time. He invited us to lunch and he shared his congratulations and appreciation for opening AWS. And he said that they would represent all the shelter residents in need of Apilo legal representation. That promise and continued interconnectedness, collaborative work with APLO and AWS is happened and continues throughout the years. Although we cluster and we uncluster, we all evolve and we grow. This is a long time, deeply trusted collaborative work. So now I am so honored and inspired as my generation passes forward our good old roots and intergenerational leadership with our next generation of leaders. Yenny Teng Lee, attorney and MLAM advocate, Victoria Hartando, supervising attorney at Apilo. Thank you, Hediana Utarti from AWS, Yenny and Victoria. You're creating and hosting today's wonderful webinar. And most of all, thanks to each and every one of you for joining this webinar. Yes, today is a meaningful day to gather together, interconnect, continue to learn and to grow.
Thank you so much, Becky. All right, everybody. We are going to start soon. Here are a few logistics to keep in mind. Our attorney, I think folks should mute yourself if you can, please. All right, we are going to start soon, everyone. Some logistics. Number one, our attorneys, I think, Becky, can you mute yourself? Our attorneys, Yenny and Vicky, will start with their presentation. They will speak for about 40 to 45 minutes. During that time, those of you who are in Zoom rooms will hear interpretation directly from our advocate or your interpreters. Please have papers and pen and write down the contact information of our attorneys in case you want to talk to them in the future. If you have a question during presentation, feel free to type them in the chat box. This is for those of you who are in the main room. In the Zoom rooms, you can do the same and your interpreters will collect and send the question to the main Zoom room. After the attorney's presentations, we will take a 10-minute or 15-minute break. For folks in the Zoom room, give your question to your interpreters. They will translate the question and send them to the main Zoom room where Yenny and Vicky are. We will return to the same Zoom link after the break, and the attorneys will respond to your question in English slowly so we can interpret them as accurate as possible. We hope to end the webinar at 5 p.m. Thank you, everyone, and I will let our attorneys start. Yenny, you can go ahead start. Thank you, everybody.
Thank you, Becky, for the warm and insightful welcome. I admire and I'm grateful for Becky. Hediana has described the spirits of the webinar well. Thank you, Hediana. I'd like to emphasize that this webinar could not happen without these wonderful interpreters and Zoom technicians in each of the Zoom room here today with us. I'm giving them a shout out in gratitude. Hi people, I'm thrilled to be here with you today. This webinar provides not only relevant legal information for you, but also a cutting-edge application of technology. What I say to you now is being interpreted in live in 4 languages in 4 different Zoom rooms. Pretty cool, I'll say. In this webinar, we will answer your questions that you have emailed us, and then some, as well as a live Q&A as time permits. When Victoria and I answer your questions, we are only providing you with the preliminary direction of your case based on the facts given to us. It is not legal advice. We don't know enough about your case to give you any legal advice. To obtain legal advice, talk to an attorney who knows your case. I will talk about divorce, domestic violence, and Victoria will talk about immigration. As an attorney, I help people to go through the most difficult period in their lives. Their families are falling apart. Their children are trapped in the process. Their sense of security is gone, and they may not see their children anymore. The hearts are breaking. The job of your and your spouse's attorney is to work together as much as possible to help make difficult necessary. Your attorney should understand this principle. There is no win or lose here. So that it's easier to understand, my approach in this webinar today is to provide you with the big picture of each topic before diving into your questions. Now, I received several questions about the general process of divorce in California. Lisa, could you please go to the next slide? Thank you. In California, one spouse can get divorced by themselves. At least one spouse must have resided in California for 6 months minimum and 3 months in one county. Here is the process. First, you file the divorce petition and summons and some other required local paperwork with the court. Afterwards, have a third person who is at least 18 years old serve or give the filed documents to your spouse. Third, you serve your financials to the other spouse and discuss custody, support, and property division. If you cannot come to an agreement, the court has to decide the disputed issues. That means a trial. At the end of the process, you will have a divorce judgment or a court order. One question asks, what happens if you cannot find the other spouse to serve the divorce papers? You can serve the person by publication. That means publishing the divorce summons in the newspaper. You have to follow specific steps to do this kind of service. The service by publication should be your last resort. If you know your spouse's address abroad, then you can ask a third party who is at least 18 years old to serve the spouse the divorce papers in person. California law provides several methods to serve legal papers abroad. Depending on the country, it might be difficult to enforce California court orders if the service does not follow international laws, such as the Hague Convention or a treaty. In these situations, talk to an attorney who knows your case in detail for legal advice. One person asks, what if I don't respond to a divorce petition? This is a situation where you have received a petition and summons from your spouse. Assuming you have been served properly, the answer depends on the case. Generally, if you don't respond, there is a risk that the filing spouse will get what the petition asks for. It can be okay not to respond if you can work out an agreement with your spouse. Now, can you represent yourself without an attorney? Yes, you can be a self-represented party. It is a good idea, for example, if the power is balanced between spouses and the marriage has only a few assets to divide, or if the spouses can work toward an agreement. But you still need to know the proper forms to file and the law. While representing yourself, you can retain an attorney for a limited scope for, let's say, consultation and document drafting. Or you can go to free services in court to help you complete documents. In my experience, in a divorce, it is best if you can set aside your differences and work toward a settlement with your spouse. This is especially true if you have a child. Children often become the victims in a divorce. When you are able to set aside your differences, you and your spouse can learn to co-parent and build a healthy relationship for yourself and your children. This is a good idea when the ex-couple does not have power imbalance. Generally, the major issues in a divorce are child custody, child support, spousal support, property division, and attorney's fees. Now let's start with the first issue in divorce, child custody. Custody can be joint or sole custody, and regarding the physical or legal custody of a child. Physical custody is where the child resides, and legal custody is about the decisions regarding the child's health, education, and welfare. Joint physical custody does not necessarily mean equal time with both parents. Initially, custody and visitation is determined from what's in the child's best interests, that is, the child's welfare, health, and safety. What's good for the child? Frequent and continuing contact with the parents. That means joint custody unless it is not good for the child, such as in the case of domestic violence or substance abuse. Generally, after the final judicial custody order, a parent who wants to change custody must show that there is a substantial change in circumstances affecting the child's welfare, which makes custody modification essential. A parent who is disabled or does not work can still have custody of the child until the lack of income or the disability affects the child's safety, welfare, and health. I have a request to slow down, so I will slow down. Stability and continuity is generally good for a child. Moving away disrupts the child's life, but if you have sole physical custody, then you have the presumptive right to move away with the child. If you have joint physical custody, then you need to show that moving away is in the best interest of the child. A parent asks, if the parent has moved to another state and the child is still in California, can that parent file for a child custody action in California? The answer is, if there is no prior court order and the child has resided in California for the last 6 months, then yes. The answer is yes. The court's jurisdiction over the child depends on the child's home state, not the parents. Again, this is not legal advice. This is just a preliminary direction. Child custody law is complex and heavily depends on the case facts. So talk to an attorney who knows your case in detail for legal advice. A mother asks whether the other parent's permission is needed to travel abroad with the child. Usually, in applying for a child's passport and at the airport, you will be asked for the other parent's written consent. Consent like this should be clarified in the divorce judgment or a court order. Both parents have equal right to their child. Where no action is filed in court or there is no court order, a parent can move away with the child without the consent of the other parent, but the parent cannot conceal the child's whereabouts from the other parent. Not all courts like this kind of move away approach. Law enforcement will not retrieve a child unless there is a court order or child welfare concerns. If there is no prior court order and one parent removes the child and conceals the child's whereabouts from the other parent, the removing parent can be charged with parental kidnapping and punishable by prison time. But where one parent is in good faith and reasonably believes that the child will be in immediate bodily injury and emotional harm if left with the abusive parent, the concerned parent may remove the child from the residence to a safer and confidential place. But within 10 days, the concerned parent must make a report to a district attorney's office in the child's original area of residence. Lisa, could you please move to the next slide? Keep going. Yeah, this one. Okay. So I was at the district attorney's office. So the concerned parent within 10 days must make a report to a district attorney's office in the child's original area of residence. Within at least 30 days, the removing parent should file a request for order for custody. A question asks, can an abusive parent get child custody after committing domestic violence? If the parent has committed domestic violence in the last 5 years, it is much harder for them to get custody. There is a rebuttable presumption that this abusive parent could not get any custody of the child. But the parent may still have visitation rights, albeit supervised. If the abusive parent is convicted of child abuse, molestation, or corporal injury, then they have no custody rights at all. Let's get into more details about domestic violence. Domestic violence, as you can see, affects the custody and spousal support issues in a divorce. Domestic violence can be in the form of financial control, emotional, sexual, or physical. Examples of emotional control include limiting contact with friends and families, threats, publishing private information about the other spouse, damaging things, insults, killing a pet, hiding passport, stalking, incessant phone calls, unwanted and harassing contacts, and many others. If you feel you are experiencing domestic violence, if it is safe, gather evidence to support your case. You can take pictures, journal about what happens, collect evidence from social media, have witnesses during the act, tell a third person what happens when it happens, make a recording to evidence the abuser's domestic violence acts, have a copy of the police report. To obtain legal protection, you can call the police and get an emergency protective order or EPO. EPO gives you protection for 5 to 7 days, but in these COVID times, it has been expanded to 30 days in some counties. Additionally, you can get a temporary restraining order or TRO for 21 to 25 days, and a longer-term restraining order called DVRO, Domestic Violence Restraining Order. Who to call for help besides the police? Lisa, could you please go to the next slide? If you feel you are experiencing domestic violence, you can call organizations like the API Legal Outreach, or the Asian Women's Shelter, or CORA in San Mateo for help. It is free. They provide interpreters and can also refer you to other resources. API Legal Outreach focuses on legal assistance like helping you get a restraining order. AWS focuses on providing food, shelter, childcare, and other things. Quora provides legal and housing assistance. You can also Google to find nonprofits like this in your area. Now here is their legal information on the screen. Who is protected in domestic violence restraining order? Not everybody qualifies. Abuser and survivor must be current or former romantic partners, like boyfriend, girlfriend, or must have a familial relationship by blood or by marriage, like in-laws, spouse, grandfather, grandmother. Now, what kind of protection is available in a DVRO, domestic violence restraining order? Lisa, could you please go to the next slide? Here are some examples. You can ask that the abuser has to maintain a certain distance from you. They cannot go to your school or workplace. You can ask for a cell phone or a computer that you use, or that you are given the pet. The abuser cannot have a gun. The abuser must leave the house. Temporary custody of the children, that's what you can ask, and attorney's fees, and many others. Violation of a restraining order can mean fines, jail, or prison time. Now, this is about, Lisa, could you please go next slide? Now, this is about the second major issue in divorce, that is child support. I received a few questions about how to determine the support amount and child support in relation to child custody. Child support is both parents' obligation. Child support lasts until the child is 18 to 19 years old. Parents cannot terminate child support. This is the child's right, not the parent's right. There are several factors in determining child support, but the significant factors are usually 1, parent's income, and 2, the amount of the child's time spent with each parent. So that means that a payer's higher income means that they pay more child support. A payee's higher income means they receive less child support. More time with the child means the payer pays less child support. The other factors in child support amount are the number of children with each parent, the payer parent's ability to pay, and others. If a parent is unemployed, to avoid paying child support, the court will impute income to the payer based on the payer's previous income or potential income to calculate the child support amount. The Department of Child Support and Services provides free services to help you get child support. Call them for help. The district attorney has the obligation to prosecute delinquent child support payers. Now, the third major issue in divorce is spousal support. There are 2 types of spousal support. One is while the divorce is pending, that is temporary spousal support. 2 is after divorce is done, that is permanent spousal support. Temporary spousal support's main factors are spouse's income and ability to pay. We use computer software to calculate the temporary spousal support. Generally, the support starts counting when a request for order for the temporary spousal support is filed. That means the earlier you file, the better. Permanent spousal support uses 14 factors to determine the amount, including the marital standard of living during marriage, the payee's ability to get work, the payer's ability to pay, both spouses' age, health, etc. It is not formulaic, and it is up to the court to weigh the 14 factors and determine the amount. How long does spousal support last? The rule of thumb is, if the parties were married for less than 10 years, spousal support lasts half the length of the marriage. If they were married for at least 10 years, the spousal support might be until death or the payee remarries. Now, if a spouse refuses to work to avoid paying spousal support, the court will impute income based on previous or potential income to calculate the support. What's the responsibility of a spouse toward the other spouse's rent payment in a divorce? A question asks. Per se, none. But you can ask for spousal support to pay for rent and groceries. Alternatively, if you have not received any spousal support after the date of separation and you have access to community funds, you can use the funds for rent, grocery without reimbursing them later. However, the fund used from community funds is capped at a reasonable amount of child and spousal support. This is the fourth major issue in divorce, property division. In divorce, each property is categorized into community property or separate property. Now, if it is a community property, then it is divided equally. What is community property? Generally, any earnings and debts that both spouses obtain during marriage until the date of separation. Some exceptions are if the earnings come from a separate property, an inheritance, a gift to one spouse only, or there is an agreement between spouses. A property can be wholly or partly community property. Any property bought during marriage is presumed to be community property regardless of the title. That means that if you can show to the court that the property is bought during marriage by the other spouse has to prove that it is separate property or somebody else's property. The judicial punishment of hiding assets could mean losing 100% of the assets. If your spouse hides assets, you may have to hire a professional to investigate. What you can do is to take pictures of valuable items in the household, mailing envelopes from relevant companies, record household spending or property transactions, and other things that you can do. Now let's talk about attorney fees here. Your attorney's fees in a divorce might be paid by your spouse if there is a significant discrepancy of assets or income and the spouse can pay. You don't have to be low income to qualify. The court usually only gives some of the attorney's fees though. Now, I am done talking about the family law and a divorce, but this next topic, Lisa, could you please go to the next slide? Yeah. The next topic is about taking care of your financials and health matters in the age of pandemic and wildfires. For health matters, you should prepare healthcare directives that will give direction to your loved ones how you want to be taken care of if you cannot make any decision anymore. Hospitals like Kaiser have pre-printed forms available for this purpose. You should also get POLST, that is P-O-L-S-T, from your doctor. It stands for Physician Order for Life-Sustaining Treatment. It is a bright pink piece of paper that you fill out and get it signed by your physician. Place it on an obvious place at home, like on the refrigerator's door. When 911 is called, upon entering your house, the firefighters and ambulance personnel will look for POLST to determine what to do with you. Now, about your financials. You should think carefully to whom your property's bank account should go when you die. You should take care of your assets when you cannot make any decision anymore in a hospital bed. In California, you can make a will or living trust. You can designate beneficiaries, do payable on death, have joint ownership for your properties and other things. Don't leave your financial matters hanging. You should find an estate planning attorney to talk about this. I don't do estate planning. Now, this is important as well. Make sure you read your estate planning documents before signing so that they are accurate. Now, Victoria Hartanto, the supervising attorney in the API Legal Outreach, is going to talk about immigration. Afterwards, we will take a 10-minute break so participants in the language Zooms can ask their questions with the help of the interpreters. Participants in this speaker Zoom can continue placing their question in the chat room. Remember, what we tell you in this webinar is not legal advice. Take it away, Vicky.
Thank you so much, Yanni. Hello, everyone. My name is Vicky Hartanto. I'm the supervising attorney for the Immigration Project at API Legal Outreach. We are a nonprofit legal aid organization with offices in San Francisco and Oakland. Today, I will cover some basic rights and information regarding different ways to obtain legal status or a green card. And also, I'll be discussing some important information about the new public charge rule, which has to do with how using public benefits may affect your immigration status. I'm going to answer many of the questions that were submitted in advance as I cover all of these topics, but in some cases there was not enough information to adequately answer the question, and you will need to consult with an attorney individually. Okay, so the first slide. Okay, so first of all, what does it mean to be undocumented? Basically,
sorry, Vicky, before you continue, it looks like our interpreters are still finishing up from Yanni's.
Oh, sure.
So maybe we could give it 2 more minutes and we can.
A little break in the middle.
Yes, thank you.
Okay, I think the interpreters have caught up, and I'm going to start again and try to speak very slowly. Thanks for your patience, everyone. Okay, so this is the first substantive slide. What does it mean to be undocumented? It means you have no legal status and likely no work permit. If you have no legal status, it is true that technically you can be deported at any time, but you should be given the chance to have a legal process and see an immigration judge first. Usually, deportation proceedings are a lengthy process that can take at least a couple of years. I strongly advise you to retain an immigration attorney to represent you if you are in deportation proceedings. There are many types of legal status. So for example, a tourist visa is temporary, just for visiting. An employment visa, for example, the H-1B visa, these are usually temporary, but sometimes there is a path to a green card. A student visa is temporary only while attending school. And then of course there's the lawful permanent resident, the LPR or green card holder. And then there's US citizenship. And then there's other legal status on the path to permanent residence or citizenship. And we'll discuss that more today. If you are undocumented and you're working without authorization or an EAD card, you will need to gain legal status if you want to stay in the US and work legally. So some consequences. If you manage to get legal status, you will have to disclose in your green card application that you worked without authorization. Generally, if this is the only red flag or issue on your application, then it's not a big deal and the application should still go through. But be aware it could be an issue. If you plan to one day apply for a green card or for LPR status, you need to try to do everything the right way. So that means pay your taxes, have no criminal charges or convictions, and nothing that shows that you could have bad moral character. Some people do stay undocumented for a very long time. If you do not commit any crimes, have no arrests, and you don't file any immigration applications, and you do not travel outside the US and try to re-enter, then you may not ever be put into removal proceedings. For certain people who have been in the US continuously for 10 years, and you can prove extreme hardship to a US citizen, spouse, or child if you get deported, you may be able to get something called cancellation of removal if you are ever put into removal proceedings. Okay, so next slide, please. Oh, sorry, the one before. Okay, there are many paths to a green card or LPR status, including the most popular is the family petition. If you are a legal permanent resident, you can petition your spouse and your unmarried children to come to the US as permanent residents. If you are a US citizen, you can petition your spouse, your children, whether married or unmarried, the children of your spouse, your parents, siblings, and your fiance. So that means no in-laws, no cousins, aunts, or uncles, only immediate family members are you able to petition for them. If you have any US citizen children, they can petition for you when they are 21 years old. It is easier and faster to petition for family if you are a US citizen than if you are a permanent resident. So here, applying, for a family petition, the public charge analysis will apply. So you need to show that you have enough income to not need public benefits. And remember, if you marry someone for the purpose of getting a green card, that is considered immigration fraud. So if the government, if USCIS suspects this, they will do a very thorough interview and investigation, and they will request evidence of a legitimate marriage and could deny your application. Okay, other paths to a green card include refugee or asylee status, U visa, that's for victims of crime, T visa for victims of human trafficking, the Violence Against Women Act, or VAWA, and something called Special Immigrant Juvenile Status, SIJS. So I will talk about that a bit more later. Next slide, please. Okay. There are some bars to admissibility based on unlawful presence. So if you have entered the US illegally more than once, or you have been in the US unlawfully for a certain amount of time, you could be barred from being admitted into the US. So the 3 and 10-year bars are based on your unlawful presence in the US, how much time has passed. And the permanent bar is if you entered the US illegally more than once. There are waivers or exceptions for the 3 and 10-year bars, but not for the permanent bar. To get one of the waivers, you would have to prove hardship to a US citizen or permanent resident, spouse, or parent. Children do not count for that waiver. Okay, next slide, please. Okay, asylum. In order to get asylum, you have to meet the definition of a refugee because you have suffered past persecution or have a well-founded fear of future persecution on account of your race, religion, nationality, membership in a particular social group, or political opinion. So this is a very specific definition, and it is not easy to be granted asylum. Affirmative asylum means you apply at the asylum office, and defensive asylum means you apply with the immigration court when you are already in removal proceedings. Okay, and then there's something called SIJS, Special Immigrant Juvenile Status. This is for unmarried persons under age 21, where at least one of their parents abused, neglected, or abandoned the child. You will also need to get a court order putting you in the custody of a legal guardian or a parent in order to get this status. Next slide, please. Okay, so the T visa that I mentioned before is for victims of human trafficking. In order to qualify, you need to, a T visa is immigration relief for survivors of sex or labor trafficking. It involves force, fraud, or coercion to obtain labor or a commercial sex act. Traffickers might use violence, manipulation, or false promises to lure victims into trafficking situations. So, for example, if your employer does not allow you to leave the house makes you work more than 8 hours a day, restricts your freedom, threatens you with deportation or calling immigration or ICE, you may be a victim of trafficking and you may be eligible for a T visa. So you should seek a legal consult. So feel free to call my office and we can do a consult and provide referrals. One question I received in advance is, the question is, I got a T visa and I filed for my children to come from Egypt and they need to get fingerprinted, but the American embassy in Egypt is closed. What can I do? Can this process be done when they come back, or is it necessary to happen at the embassy? So for this specific situation, I recommend you retain an attorney to assist you with this. You should also email the US Embassy in Cairo. That's consular Cairo NIV@state.gov. That's the email. And request an appointment urgently, telling them the deadline by which you need it completed. If your T visa is expiring in the next year or so, it is probably best to apply for an extension based on waiting for the adjudication of your children's T visa applications. If you are still unsuccessful in getting biometrics or your fingerprinting done, you may try to submit instead, one, a criminal record or background check issued by authorities in Egypt, and two, a declaration from each child that attests to their personal knowledge of their own criminal history. Okay, moving on, the U visa is for victims of a crime in the United States, and there's a specific list of crimes that qualify. And you must have experienced substantial physical or mental harm from the crime. And you have to have information on the crime and have been helpful or likely to be helpful in the prosecution of the crime. Okay, VAWA, that's Violence Against Women Act. That is immigration relief for survivors of domestic violence. So the victim must prove that he or she has been battered or subjected to extreme cruelty by a US citizen or permanent resident spouse or parent. This relief also applies to the abused parent of a US citizen child. Okay, so that means if you have been the victim of domestic violence and your child is a US citizen, then you may be eligible for immigration relief or a path to a green card under VAWA. If you already have a conditional green card based on your marriage, but the marriage has ended or your spouse is abusive, you can also apply for, it's called a petition to remove conditions on residence. That's Form I-751. Just pause a little bit, but next slide, please. Okay, public charge. This is really important. There's been a lot of misinformation on this. So public charge is a new immigration rule since February 24th, 2020. What is public charge? It is part of the screening process when someone applies for a green card. If you are considered a public charge, you cannot get permanent residence status. Okay, but who does it apply to? It only applies to people who are applying for their green card through a family member or a small business owned by family. It also applies to green card holders who travel abroad for more than 180 days or travel abroad and have a criminal conviction, criminal record. So the main takeaway is most immigrants do not need to worry about public charge. Okay, it does not apply to people who are applying for a green card. Sorry, it does not apply to people who are not applying for a green card. And it does not apply to legal permanent residents who do not travel more than 180 days or with a criminal conviction, or US citizens. It does not apply to refugees, asylees, and people seeking cancellation of removal. Doesn't apply to special immigrant juveniles or visa holders, and doesn't apply to VAWA, U visa, and T visa applicants or holders of those status. Okay. Yes, you may be eligible for unemployment benefits and also stimulus funding if you have a valid work permit, an EAD, and a social security number. So, for example, an asylee or asylum seeker or DACA recipient that has work authorization, you may be eligible for these benefits. And just to reiterate, remember, public charge does not apply to asylees, anyone applying for asylum or who has received asylum. So you should go ahead and apply for unemployment benefits and other government benefits like CalFresh, Medi-Cal, etc. There will be no harm to your case. All right. So let me answer a few other questions that we received in advance. In January 2020, this is the question, I filed my, oh, sorry, Lisa, you can go to the next slide. Okay. I'll just have this slide up while I answer these other questions. So the question is, in January 2020, I filed my petition for citizenship. Due to COVID, I believe that processing times have been delayed, but my green card will expire in January 2021. My question is, what options do I have, or what should I do if my citizenship is not finalized before January 2021? Okay, so the answer is yes, USCIS is taking longer, and many interviews were postponed due to COVID. But they are now open again, and interviews are being rescheduled. Even though your green card will expire in January 2021, you will still be a permanent resident. So the expiration of your green card does not change your LPR status. If your job does not require a current green card on file, then you can just wait for your naturalization application to go through. If you do need a current green card for your work or any other purpose, like applying for public benefits, then I recommend you apply to renew your green card right away using Form I-90. Okay. The next question is, I left on vacation with my husband and children to our country of origin, and my husband took my green card and passport and left me there with the children. How can I get them back? So you should contact a US embassy about your passport and call USCIS or speak to an immigration attorney about options for getting back into the country without your green card. You can apply for a replacement green card, but that process can take several months to a year. Okay. The next question is, I have a 10-year green card and I have only one more year until I become a citizen. Will my restraining order and domestic violence case impact my citizenship application? So it could. It depends on what happened and when did it happen. This information should be disclosed already in your application or at your interview, and they will run background checks. So it depends on what, if any, arrests or convictions there are. To apply for citizenship, you need to establish good moral character. And in particular, they look at the last 5 years. So I do recommend you retain an attorney before your citizenship interview. Okay. A few more questions here. The next one is, can my husband bring his new wife to live in the US from overseas while still married to me? So the answer is no. The new marriage is not legally valid if he is still married to you. So to qualify for a marriage green card, he must provide a marriage certificate as well as evidence that any prior marriages have been legally terminated. So even if marriage to more than one person is valid in the home country, it is not legally recognized under US federal law. Okay, the next question is, I came to the USA in the year 2017 via a diversity lottery visa. At the time of application, I did not put down my elder daughter's name without realizing it. As soon as I came to the US, I have started my elder daughter's process to bring her here. It's taking long. Last I checked, she's still waiting for her interview to be scheduled, but I am worried. So yes, it can take a long time, and you can call USCIS to ask about the status of that application. And you can consult with an immigration attorney about your specific case to see if there are any issues. Okay, next question. My daughter, who is 24 years old, came here to the US in March 2020 with derivative asylum status. I am the primary applicant. She applied for a travel document but got rejected. She went back to Nepal on October 2nd, 2020, as she had to go in order to complete her one-year internship program for her degree. Is there any way that I can still bring her here after 1 year? The answer is, without valid refugee travel documents, she may not be allowed to enter the US, but it is at the discretion of Customs and Border Patrol to make that decision. And there is a chance she could be allowed in without these documents. I would consult with an immigration attorney to see if there's anything she can do to legally enter the US again in her specific case. You can also file a family petition for her once you get your permanent residency. So you should go ahead and apply for LPR status as soon as you are eligible. Okay, next question. My husband is the primary applicant on an asylum pending visa application, and I am his dependent. I want to divorce him, but I'm worried about my visa status as I don't want to go back to Nepal. What do you suggest in this situation? So it's unclear what kind of visa you are referring to here. If you and your husband are asylum applicants, I think if you have a strong basis for applying for asylum yourself, you could file for asylum on your own and separate your cases. So I would go ahead and consult with an immigration attorney about your specific case. Next question. I have sponsored a couple of my friends from Nepal as they needed sponsorship in order to come here. They got the diversity lottery. Recently, I am hearing that if they get into any public charge or other trouble, I will be accountable to the government. How will their public charge record affect me? Okay, so I had to look this one up, but as a sponsor on their affidavit of support, their declaration that you signed, you did not promise to support your friends financially, but you did agree that if your friends end up getting certain public benefits by fraud, that is by misrepresenting their income, your income, or their immigration status, then you are responsible for reimbursing the US government for the cost of those benefits, those public benefits. This responsibility lasts for 3 years. Okay, we're almost done with questions. There's a couple more. I have applied for asylum and have been waiting for an interview since 2015, but nothing is happening. I am worried about my wife and children back in Nepal. I want to go back. Now, how do I withdraw my application, and how will withdrawal affect me and my family in a future USA visit if we ever want to come here? Okay, so you can request an expedited asylum interview. The asylum office encourages this if you have a reason for needing to have your interview done sooner. It is strange to be waiting since 2015, so I would definitely request this. You are also allowed to withdraw your application simply by writing a letter to the USCIS office that is handling the application. However, if you return to the country that you claimed persecution from, so if your asylum application is based on persecution in Nepal, then you are essentially abandoning your asylum case, and you may have to find another way to legally enter the US. Okay, the next question is, my husband, my younger son, and I came here a few years back. Due to age limitation, my elder son is in Nepal. How do I apply him legally to come here permanently? So I can't answer this question until I know your status. If you are a permanent resident, then you can petition for your son to come here as long as he is not married. Okay, last question that we received last minute. So not everyone may have a translation for this, but I'm gonna read this in English. The question is, how can I issue an urgent travel document for my wife to see her sick mother, so basically on her deathbed? My wife has been granted asylum status a year ago and will apply for a green card in 2021. Does a travel document affect her case in any way? Okay, so again, we do not recommend for asylees to travel back to the country where they claimed persecution. So if her mother is in her home country where she claimed asylum from, we don't recommend her to return to the home country until she is a US citizen, because it could jeopardize her asylee status. So she technically can travel back to the country, but she would be taking a huge risk that she may not be allowed back into the US and she could lose her status. If her mother is in a different country, or she wants to take the risk of losing her status, she should apply for an emergency refugee travel document or advance parole by contacting USCIS at 1-800-375-5283 and requesting an in-person appointment to get emergency travel documents. She will have to complete Form I-131, pay the filing fee, and have documentation of her mother's urgent condition or other reasons for the emergency travel. She should not leave the United States without travel documents. Otherwise, her green card application will be affected. Also, she will be subject to inspection when she returns to the United States. So she cannot have any criminal history or leave for more than a short trip. Okay, so thanks for your patience. Those are all the questions. Just to close, I work for API Legal Outreach. The Immigration Project at API Legal Outreach handles all of these types of cases. So asylum and removal defense, special immigrant juvenile status, naturalization or US citizenship, Violence Against Women Act self-petitions, the U visa for victims of crime, the T visa for victims of trafficking, DACA, permanent residency application and renewal. And we also have virtual clinics for legal consultations and review of documents. So please call the office and go through our intake process if you're in need of legal assistance. We do have other programs at my organization. We handle housing, tenants' rights, domestic violence, family law, elder and disability rights, anti-human trafficking, and we have a youth program. We have offices in San Francisco and Oakland, and we serve Bay Area residents. The number is 415-567-6255. Thank you so much.
Thank you, Vicky, for your generous time and informative presentation. As we mentioned, there is going to be a break for 10 minutes. During can ask questions verbally or by texting in the Zoom chat box, and the participants in the speaker Zoom can continue asking questions in the Zoom chat box. So now it's 4:20. So at 4:30, the speakers will return to answer the questions asked during this webinar. All right. So we are taking a break now. Hello. So it's 4:30 and we're back. Yeah, is everybody back? Language Zooms? Lisa and Jessica, are people in the language Zooms ready?
We haven't heard back from them just yet. I think they
Mm-hmm.
are busy in their rooms.
Okay, we'll wait a
But
little bit.
I think it looks like we have one Zoom room that's ready, and I think the others should be ready soon. Many questions are coming in, and I think we can also add those questions later for if we don't get, because we already actually have many questions to get through.
Yeah,
Looks like
we
we're-
only have like 30 minutes, right, before
Yeah.
5 p.m.
Yeah,
and then,
let's get started, I think.
yeah, okay. And
And we
then
can take
I like,
some pauses as well.
all right. So, Vicky, because this is not going to be simultaneous interpretation, so we're going to have to, have short sentences and then stop, let them catch up, and then so on and so forth. Yeah?
Okay.
Okay. All right.
Okay.
Go ahead.
So this is for Yanni regarding property and banks. Question is, can the property be divided if the house was bought before the marriage, and how about the bank accounts?
Okay. Thank you for the question. So, as I mentioned, that a property, okay, can be wholly community or partly community. That means if it is a house bought before marriage, okay, and the mortgage or the maintenance or the remodeling, okay, is paid during marriage, that means that part of it is gonna be community. So you can take that part of it that is community and then calculate it. You should hire an attorney to do this. And then divide it into half and half if the two of you cannot reach into an agreement. Bank account is the same way, but it is more, I think, complicated if the bank account has been used for many different purposes and the marriage is a long-term marriage. So what you have to do is to identify, what income has come as of the date of marriage. You trace that, you call it tracing, okay? Because community property is formed starting generally from the date of your marriage. Any income that you make, that your spouse make during marriage, until the date of separation, that is considered community property. I think that should help with the direction of the answer. Yes, the case, the question.
Thank you. Now, I'm going to rotate also to the next part for Vicky, path to permanent residence.
Sure.
Question is, we applied for a 10-year green card in January 2020. If I move, do I need to tell the USCIS?
Yes, you should just file the form AR11, change of address form, or if you have an attorney, have them update your address for you.
Okay. And then the following question is, I want to get divorced but scared to lose my immigration status. I applied for a 10-year green card in January 2020. Can you
Okay, yeah.
speak on that?
Yes. So if you applied in January, then the application should be processed very soon. And I would probably wait for that to go through first. You can check the case status on the USCIS website, or you can call them. If you cannot wait, then you can file Form I-751, removal of conditions on residency. You will need to provide evidence that you married in good faith originally and not for the purpose of obtaining a green card.
Thank you. I'm pausing for a while.
I think that's good. I think it'll take time for the Zoom language to catch up.
Okay. This is also part of the permanent residence. I have 3 more questions here. I have a friend whose asylum was denied by the High Court in 2009. After that, he got married twice, got divorced, and was denied again, as court thought those marriages were fraud. Currently, he has EAD through TPS. Can he still appeal to court for his asylum status? Or are there any other alternatives for him?
Okay, thank you. So you only have a limited amount of time to appeal a court's decision. So the time for an appeal has passed. But if there are changed country conditions or the situation has changed so that they have a new or stronger claim for asylum than before, then they can apply again, or file a motion to reopen their old case.
Thank you. Follow-up question. What are the updates on asylum applications as of now? I mean, during the COVID-19 pandemic. The question, person asking the question has been waiting for their interview.
Right, well, if your asylum application is pending before the asylum office, they are going forward and scheduling interviews and rescheduling interviews that were canceled during, the shelter in place period. So if you would like to have your interview done sooner, I recommend you contact the asylum office that is processing your application and ask about the status of your interview, and you can request an expedited interview if you have a good reason for needing one.
thank you. Last question from this category from a participant based in California. Where to go if the embassy is closed in Egypt? How long can we renew the application if the embassy is closed? We believe this is an application for her children to join her in the US.
Okay, thank you. I think I answered this question or something very similar earlier. Just pull up my notes. Okay, so if the embassy in Egypt is closed, so first of all, I'm not sure what application this is in regards to, but if you need the U.S. embassy in Egypt, you could try that email address that I gave earlier. That's Consular Cairo, NIV@state.gov, and try to request an urgent appointment with them.
Sorry, could you repeat that one more time, the Consular Cairo?
Yeah, Consular Cairo, N as in Nancy, I as in iguana, V as in Victor, NIV @state.gov. So try that email address. Otherwise, I'm not sure what else you can do with a closed embassy. Let's see. How long can we renew the application?
Sorry to interrupt, Vicky. Yeah. There is a request for you to speak louder.
Oh, I'm sorry. Can you hear me? Okay. Sorry, I'm just trying to read the question again. Yeah, you can contact USCIS and let them know about your situation to see if you can get some sort of extension on the application if you cannot reach the embassy in Egypt. Okay.
Thank you. And this is back now to Yenny for custody. If the mother is not working, can she get custody?
So I answered a similar question about that just now, just a couple of hours ago. So the answer is yes, you can still get custody. The way California court sees it is that parents have rights to their children. Okay. Now, income should not be something that is used against parents to not have custody. Let's say you don't work. However, if you don't have income and there is no other income, and that lack of income affects the child's welfare, safety, health, then it might affect your custody rights. Thank you.
Thank you. Another moment of pause. Now, for restraining orders, question is, do I need a restraining order to prove good faith marriage? can I prove bona fide and abuse at the same time?
Sounds like an immigration question. Is it?
It says about restraining order.
Because in restraining order, we don't really have to prove a bona fide marriage. Are we saying, I see. Okay, I see. So if this is not about immigration, okay, if this is about domestic violence, I talked some time ago about who is qualified for restraining order protection. I think you probably are asking in that scope. Now, yes, okay. So I said that not everybody qualifies for domestic violence restraining order. An abuser and survivor must be current or former romantic partners, like boyfriend, girlfriend. Must have familial relationship by blood or by marriage. Now, you don't need to prove this is a bona fide marriage, because just boyfriend, girlfriend, living together, having dates, those already count to qualify under domestic violence protection. Okay. Now, if you feel that you might not in a boyfriend girlfriend situation or in a marital situation, there is a civil restraining order that you can qualify for. Okay, from harassment, from violence, not only domestic violence restraining order. Thank you.
Yenny, can I, in case it is an immigration question, can I talk about that? So I'm positive the context, but if it's immigration, it sounds like the question might be about if you have a marriage green card and you are in an abusive relationship, you want to remove the conditions on your residency. So that's Form I-751. Yes, you need to show both that the marriage was bona fide, that it was there was a real marriage originally, and you did not marry for the purpose of getting a green card. And at the same time, you also have to show some evidence that there was abuse in the marriage, or that the marriage is over. So you can show both.
Thank you. Okay, this is also perhaps open to both Yenny and Vicky. The question is, daughter applied for a stepmom. Stepmom in Indonesia applied in US Embassy. They found that the date for her father's divorce letter is different from the actual divorce letter produced by the Indonesian government. So the application is denied. Can they reapply? Father is waiting to get his USC.
Sounds like your area, Vicky.
Yeah, that sounds like an immigration question. So it sounds like the family petition was denied because there was some discrepancy in the date of the divorce. I do think you can just apply again. There might be an option to file a motion to reopen the case. Usually you can do either one, a motion to reopen or file a new application. I do recommend that at this point that you retain an attorney to help you with the application so you don't run into any further issues.
And this should be an attorney that is well versed in the immigration law in the US.
Right.
I am going to pause for a second here to let the translators and interpreters work. Okay. Now then, this is for Yenny. Proof of residence. Question is, my name is not on the lease and I will need it as proof of residence. I don't know the owner and I have never seen him. I only have mails that I receive at this address as proof. Is this enough to prove my residency? If not, what can I do?
Thank you for the question. So this is going toward the court's jurisdiction. So in California, you have to reside here for a minimum of 6 months, yeah, in California, and 3 months in the county. Now, if this later on becomes a problem, you can bring out your mail. Save those mail, those letters that they have a date, right? So save them, save whatever evidence that you can have to show later that I have resided here, for 6 months in California and 3 months in this county. Okay.
Thank you. And one other category, proof of relationship. The letters that I need to get from friends or family to prove the relationship has to be from his friend or just any people who know us. And there is also a request to speak louder. Thank you.
Is this going?
This is going for Yenny.
Okay. So the question is to ask for proof of relationship in relation to domestic violence restraining order?
Is a good question. It does not say, but let's make that assumption for now.
Okay. So the domestic violence restraining order, the law, as I mentioned, that it is qualified only for people who are survivors and abuser must be current or former romantic partners like boyfriend or girlfriend, and must have a familiar relationship by blood or by marriage, like in-law, spouse, grandfather, grandmother. If in a situation where you are not married to the person, to the abuser, the other side, the opposing party, okay, then yes, you will have witness. If this is later on becomes an issue, that that the relationship becomes an issue, should you file under DV, domestic violence, or should you file under civil harassment or civil restraining order? If this becomes an issue later on, you can have declaration of witnesses, or they can testify in court about your relationship. You can have proofs of text messaging, that he chats, that he or she sends you. You can have proof with gifts that he or she has sent you, all the sweet words, and so on and so forth. So don't throw away those little things, pictures together, the times that you guys spend together, basically. All right, that's the answer to to that question.
Thank you. And this is for Vicky about undocumented. The Trump administration recently sought to exclude people in the US from the 2020 census data. Does he have the right to separate the data as an undocumented and documented and citizen? If the court allows the Trump administration to release undocumented individuals, is there a greater possibility of deportation?
Thanks, Lisa. That's a great question. I think this question is before the courts. So it's going to be decided in litigation before the Supreme Court. So I don't know what the court will decide. I think that it's absolutely outrageous that the Trump administration is trying to collect data and differentiate documented versus undocumented on the census. I think advocacy groups will fight this very, very hard. In the case that the court does allow this extra information to be collected by the census, I still think it's unlikely that there will be increased deportation of undocumented persons who do not have any criminal record or any prior orders of removal or deportation. So I think that mainly undocumented persons who have a criminal record or who have a prior order of removal, they might be in more danger of being deported, but not for others. And I think that all of the immigration groups will fight very hard to prevent increased deportation from happening on the basis of census information. But, you know, at the same time, this is the Trump administration, and they are trying their best to attack immigrants in every way. And they have been making a push recently to step up ICE enforcement. So that's unfortunate, but I have hope that it won't come to that.
Thank you. And we are coming to time, but I have two more questions. One, again, also for Vicky. Does the public charge applies to derivatives of asylee, especially to children under 21 years of age?
Yes, good question. If you are a derivative of an asylee, then you have derivative asylum status, and public charge does not apply to you. Or if you are an asylee and only, you know, or if you have any kind of status and only your children are using public benefits and not you, that does not count against you in the public charge determination. Okay.
Do we have only one question left, Lisa?
We have one question, and There are 3 other that just got added afterwards.
So we are cutting off this webinar at 5 p.m. We will need to stop here. Our interpreters have been interpreting for the last 2 hours. If we have a lot of questions asked during this webinar but didn't have enough time to answer, we are planning to do a second installment of the webinar to answer your questions. Now, if you haven't already, now you fill out the registration form so that we can send you the information regarding the second webinar installment. The technician can post the link, or will post the link to the registration form in your Zoom chat box. We hope that this information that we provide here today is helpful. Find an attorney who knows your case to get legal advice. Thank you for coming. See you next time, and stay safe out there.